Another legal topic, 2 in a row, really hard, really dry, but hopefully I can share with you some insights. Yeah, as mentioned before, my name is Fabian Masurat. I'm a tech, data protection and gambling lawyer from Wessing. Wessing is a law firm with offices in Hamburg, Berlin, Munich, Frankfurt, Düsseldorf, and all over the world. We are with about 60 lawyers in the tech area, one of the biggest tech law firms in Germany. Besides the kind of self-naming of data protection, IT and gambling lawyer, I would consider myself as well as a positive-minded lawyer. And I think it's quite rare as a lawyer calling oneself this, because normally as a lawyer you're always dealing with problems, no-goes, don'ts, especially in the area of data protection. Since the GDPR took place, I think it was a mess for a lot of companies, because their data protection officers are always saying, no, we can't do this, and that's it. And our approach is a bit hands-on. I mean, legal requirements are always the barrier. We have to stick in it, but we want to do the business for sure, and we have to guide every company through these rules. So today I want to talk about general legal requirements for affiliates based on the view from the German market, and then a bit about the new rules in Germany for affiliates in the online gambling industry. They happen a lot, and there are a lot of dramatic changes. In general, when we talk about e-commerce is an area which is developing so fast. And I talked a few weeks ago with some guy in the area of AI, artificial intelligence, and they are saying from a technical point of view, they are 2 years ahead from the technical hardware. They are 2 years ahead with their programs, and they are waiting for the hardware to catch up. Talking about laws, especially in Germany, our civil laws from 1900 and slightly adapted all the time. I think we can argue laws are even way more behind. So we are in an area always developing, always thriving, and we have the law to catch up. Nevertheless, in the last few years, there were a few clarifications with regard to do's and don'ts for affiliates, and this is I want to talk about you really briefly, and hopefully you know all these points and said check, you all have this implemented, good for you. Then we can talk about the new changes for the gaming sector. But if you are compliant with this, please check again, and be sure that you take this into consideration. Talking about affiliated marketing, I mean, the conference has affiliate marketing in its name, so I don't have to explain to you what affiliate marketing is. But just really quick from a legal law point of view, affiliated marketing is nothing more and nothing less as a kind of a commission model. We have different than the ordinary influencing marketing, where you can just share a link. I bought this jacket here, and you get paid because you share this link and make advertising. For affiliated marketing, we need normally a result in a specific referral. And on this referral, a registration happened, some goods were bought, but we need a certain result. This is, from a law perspective, the difference. The kind of extraordinary point is that we don't have a contract with a customer. As an affiliate, you want to receive your payment from the merchant or from the brand you are advertising for, not from the customer. The customer is buying with a brand. And this is, under a legal point of view, something really special. Because in this connection, we don't have a contract, but as mentioned before, we want our money based on this referral. So we have to show somehow that the referral or this act, this registration bought of goods, happened through our referral. And this is the first point, the first compliance point we're talking about. Often these proof of referral happen with cookies, with tracking, and this is the biggest issue so far with regard to data protection. I know data protection, GDPR, nobody can hear it anymore, but this is an important topic to set up a compliant business model for affiliates. So when we're talking about tracking, we often talk about products from US companies, we're talking about often shifting data through the US, so there are a lot of numerous problems there. Often you need SCCs, standard contractual clauses, and you need normally always the consent of the consumer. So if you are setting up your model like with tracking and the consumer doesn't even know about this in the privacy policy, don't consent to the cookies set, this is a problem. One could argue how they will find out. It's happened like behind closed doors, so to speak, in the system. They won't find out. What's happening right now? A lot of consumer complaints based on an insufficient privacy policy are going to the authorities in Germany, and then they are asking not about your privacy policy. They're asking about your whole business model, and they're asking and asking and asking and asking and more, and they don't let you off the hook. So be sure. At some point, the authorities will request certain proof that your setting is compliant with data protection law. Another big topic are information obligations. As an affiliate, you are required by law to show that is advertising happening here. So the decisive factor is the commercial interest. And I assume everybody wants to make money, so everybody has a commercial interest. So what's happening here, you need to show it with a banner clearly separated from the context, even better with a small note advertising, or sometimes you have in a footnote that is commercial interest, you will receive salary on this link. There are problems in regard to influencing marketing. When influencer put out a link, I bought the jacket here, and don't mark sufficiently that they receive money for this. And long story short, you have to mark somehow that the commercial interest is on your side and that you receive some benefit in providing these links. In practice, you see all the time small shopping trolleys. You see all the time really small footnotes. This is in general not sufficient. Please make sure that it's clearly separated from the context in general, not like included in the text, not a shopping trolley, not a small footnote. Make it sure that you receive something for this recommendation, for this referral. Another point is tax obligations, but I'm not a tax lawyer, so I try to make it really short. Please pay your taxes, and please inform yourself whether the tax rules of the specific country apply to you. So please make this sure as well. Another big topic are contractual obligations, and this is a topic. In the first look, it should be clear. I told you about the setting. You don't have a contract with a customer. You always only have a contract, best case, with a brand or with a merchant. And we see it all the time, especially with small affiliates. What's happened first? Banner up. Second, clicks, clicks, clicks. And then they want to, at the first stage, they receive their salary for their referrals, but they're growing and growing and growing, and then you don't have a contract in place. So please, contract first, do the paperwork, and then set up the banners, then start working. It's really essential. And when you're talking about a contract, it should be really basic, but there are some points, they are obvious, but should be included in such a contract. So for example, who are the partners? Who are the contractual partners? Often they're like subsidiaries or intermediary companies in between. Who's the partner? Who's doing the advertising? What is the subject of the contract? Are you just what are your obligations? On which websites, for example? Obligations from the merchant. Are you require some some information regarding the content. Are you requiring information regarding pictures? Are you requiring some stuff that should be laid down in the contract as well? And of course, the obligation of the affiliate itself. Is there certain business hours? You should have the website online. What happens when the service stops? And most important, payment regulations. You should really clearly state when payment is received by affiliate. Is it only for registration? Is it when the customer bought a specific product? What happened when the customer withdraws the contract in general? Is payment then still on, or should it be deducted? So these are really important points, and last ones are applicable law and contractual language and place of jurisdiction. If you have such contract in place, good for you. If you don't have a contract, please wait after my session, then we can have to set one up for you, because dealing without a contract in long term, it's mayhem at some point. Then we have some general obligations. I don't want to dive in too deeply as well. Copyright, trademarks, and competition law. This is something you should take into account as well, and you should be aware of. And now I'm coming to an important part, talking about liability. And this is the kind of status quo right now. And then I want to talk to you about changes with regard to online gambling. When we're talking about liability, yes, the brand can be liable for the affiliate and vice versa. From my first side, are you liable as a company for your affiliate? This could be happen, yes. Is there unfair advertising? Is there wrong labeling? Are there no sufficient information obligations, as I told you before? Then you could be liable for the wrongdoing of your affiliate. However, if you have set up a sufficient contract and monitor it regularly, then you could be excluded and could say, I did everything on my power, I monitor closely, but it was the fault of the affiliate. This is really common, so if you break it down, if you don't force your affiliate to do intentionally something wrong and monitor it closely, you should be in a safe spot. There was a recent judgment with regard to Amazon's marketplace, and there was no contract between the merchant and the affiliate because it was installed about the Amazon affiliated program, and the decisive factor in this regard was influence on the affiliate. So if you ask the affiliate to advertise the proper way, monitored, you should be good to go in this regard. Switching the perspective, could you be as an affiliate liable for the brand? Yes, that's possible as well, but even a bit rarer because misleading advertising, copyright infringement, stuff like this, you should check this before and check the banners you want to produce if you receive it from the merchant directly. There's room for liability, but it's quite rare in general. So with these in mind, you are liable at some point, but I think if you don't do it intentionally, you should be good to go and you should be safe. However, and now I'm coming to the changes with regard to online gambling, and this is something really new. There are new rules with regard to affiliate marketing and for virtual slot machines and for poker, and the new rules are prohibition of turnover revenue share. So the payment has to be clear in advance and cannot base anymore on the losses of the player. This is point one. We heard it before in America. This is a total new change. Then we have advertising hours. It's now forbidden to advertise between 6 a.m. and 9 p.m. for affiliates in general. We ask the authority, how should an affiliate advertise or switch off the websites? It's technically not possible. Do we have a solution? What was the answer? we are only controlling the rules. We don't make them, and we don't know about how to take them, how to implement them. It's maybe I talked at the beginning about this. It's old rules targeting like television, targeting radio, where it's easy to switch off or book a slot at a specific timing. But these rules are mayhem when it comes to online gambling. So we will see whether we get some clarification, but right now the answer was no, it's forbidden. Forbidden to advertise. When you talk about kind of displaying the app in the App Store, to my knowledge it's even not possible to switch it off as well, so it's really hard. So we are hoping in this regard to get some more clarifications. Influencing marketing in general is forbidden. Right now it's unclear what is influential marketing, what is it in general, so there will be some clarification soon. My assessment so far, all these live streams, live Twitch channels where somebody is playing, this is forbidden in general. When you are reading the explanations on the Interstate Treaty on Gambling, there's mentioning, when you see somebody play and you see his emotion, it could attract players even more. And when it comes to social media platforms, there's like the age control is a bit sufficient KYC process in general. So when it comes to influencer marketing, these live streaming should be not allowed anymore as well. And now I come to the kind of dramatic change. From a gambling operator, it's not allowed anymore to advertise via an affiliate who is advertising for illegal gambling. Once again, you can't have an affiliate who's advertising for a licensed operator alongside a non-licensed operator. In Germany, we have a so-called whitelist for gambling. On this whitelist, you can see every licensed operator. Who's not on the whitelist is considered illegal gambling. Maybe you could find small exceptions for ongoing applications, operators who have an application number. This is in a gray zone, but according to the regulator, who's not on the whitelist is black market. And you can't advertise an affiliate alongside these whitelisted and blacklisted companies. Now we can say again, okay, liability, if you don't know, if there's close monitoring. Now, there's one extra top on from the regulator. If you use affiliates who are advertising black market and white market, you could lose your license as an operator. And this is like the first regime switch from, doesn't matter if you do it on intent, purpose, or not close monitoring, it doesn't matter. You can lose just your license. It started slowly with the PSPs, who are not allowed anymore to provide payment services for illegal gambling as well, so they want to dry out the market. And now they start with affiliates, so that as an operator you're not allowed anymore to choose such affiliates. So what we will see in the next year, when the new authority is staffing up, when they install watchdogs, and they launched already a whistleblowing system where you can notify the authority when something like advertising for illegal gambling is take place. So, but this is a dramatic regime change, and if you want to operate on the German market as an affiliate, you have to take this into account. You have to take that you are aware of the rules, otherwise the operators in the future won't work with you together because they don't want to use the license. So how can you turn it into a benefit for your company? I mean, if you want to stay on the German market and advertise under these conditions. But bring your compliance team out. So go in the basement, turn on the lights, unlock the door, let the compliance team out again, and take them with you and show that you know the rules. What we did for our operator clients, we have to check the affiliates now, whether they're fully compliant or not. But turn it around as an affiliate. Bring a kind of legal opinion with you, bring a small certification that you know rules, that you are only advertised with licensed operators, and then you should have like an enormous advantage in the market. Especially when you're like for a long time in the market, you have a lot of clients, you have to do real tail cutting to do a proper and legal advertising in Germany. So, long story short, take compliance into account, bring your compliance team, and be aware of the changes, especially in the gambling area. And it's to be seen whether they try to implement these in different areas. Right now, it's dramatic change in this regard. And yeah, thank you for your attention.